the other bulk of the cases as of now, anyways, that the court's going to hear, and those are sort of like they're coming out of the Fifth Circuit. Just tell us a little bit about the Fifth Circuit, because this sounds like the strategy was you get a circuit that's going to create all of these. That's basically going to be a pipeline to the Supreme Court, because it's going to find, it's going to be the sort of, I don't know, the USS Enterprise, the Star Trek version here. We're going to cross boundaries that we've never crossed before to see where we are at the Supreme Court.
Yeah, I mean, I think it's, I would make more of a Star Wars joke than a Star Trek joke if we talk about the Fifth Circuit, because there's no greater hive of scum and villainy in the federal judiciary.
Okay, fair.
Yeah, the Fifth Circuit is, and there's just no charitable way to put it. It is a bench dominated by cranks. Donald Trump appointed 6 people to the Fifth Circuit. It had long been a particularly extreme court, and now, I mean, the stuff coming out of the court right now doesn't even resemble law. So, like.
And just to be clear, just so that people know, because I'm not sure people are familiar with this, there are 13 circuits around the country. This one represents Louisiana, Mississippi, and Texas for the most part, right? I mean, there may be, I'm not sure, that's just broadly speaking. And so if you sit on that court, you're basically nominated with the blessing of the senators from those states. So you get a sense of like, who the filter is, just to be clear. And like you say, 6 appointed by Trump, 12 by Republicans out of the 18.
Yeah. So the history of how the Fifth Circuit got to be so crazy is that there is this thing called the blue slip, which used to mean that any judge nominated from, or at least during the Obama administration, when Senator Leahy took it a little too seriously, basically, home state senators had an unlimited power to veto any judicial nominee to a federal judgeship in their state. And so, we're talking about Texas here. That means that Ted Cruz had an unlimited veto power over anyone appointed to one of the Fifth Circuit seats in Texas. The Mississippi senators had an unlimited veto power. And so, like, Obama, I mean, I think he appointed 1 or 2 judges to the Fifth Circuit, but like, there was basically a blockade. And Trump came into office with a bunch of Fifth Circuit vacancies that should have been filled by Obama. And then Trump filled all of those, plus all the vacancies that opened up while he was president. And so that's why you had this court that was already fairly extreme that just became loopy. And so to give you a sense of the loopy stuff they have done. So there's a case being argued tomorrow, actually, where the Fifth Circuit declared the entire Consumer Financial Protection Bureau unconstitutional. Now, if this entire CFPB is unconstitutional, that means we have basically no consumer banking regulations. It also means, like, there's a bunch of laws that banks have to comply with, and the banks need someone to write rules telling them, like, in specific detail how to comply with those rules. Like, if you've ever signed a mortgage before, all those documents that you have to sign that use all that thick boilerplate language, many of those documents are written by the CFPB. And if the CFPB doesn't exist, the banks don't know how to comply with the disclosure rules and various laws that they have to comply with, which means that they cannot issue mortgages. And if they cannot issue mortgages, then we potentially lose 17% of the US economy overnight, and that's a Great Depression level event. So you have the Fifth Circuit handing down this decision that makes no sense. I mean, I can go into why they said that the entire federal agency is unconstitutional, but it makes no sense. That would have sweeping catastrophic consequences for the world economy. Would do more damage to the United States than like anything since Pearl Harbor. This is the kind of reasoning that we've got coming out of the Fifth Circuit.
And it's based on a very sort of bizarre reading of Congress's ability to appropriate appropriate funds and to, I guess, to sort of, decide how. I mean, it's specifically written in there. I don't know how they interpreted it that way. I mean, the language in the Constitution is you can't spend money from the Treasury unless Congress says you can. And Congress says you can here in this situation. That's it. But okay, tell us some more of these cases, because there's going to be a series of these things. At one point, does the Supreme Court say, "Hey, Fifth Circuit, take it easy"? Yeah. Like, I mean, you're taking up too much time.
To be honest, I am fairly optimistic that the Supreme Court's going to lay some smackdown on the Fifth Circuit. They have laid a little bit of smackdown already in previous terms on the Fifth Circuit. I mean, look, I don't like Amy Coney Barrett. I don't think she's a particularly good judge. I don't appreciate the fact that she voted to overrule Roe v. Wade. I don't appreciate that she supports the major questions doctrine. I don't like a lot of things that she does. She's not a terrorist. Like, she doesn't actively want to destroy the United States or like set a nuclear bomb off in the middle of our economy. And that's what would happen if the Fifth Circuit was affirmed in the CFPB case. So like, I'm fairly confident the Fifth Circuit is going to get a big old fist brought down upon them there.
Are there other cases? I know you just got a couple minutes here. Are there other cases that you think that the Fifth Circuit is pushing that is going to be problematic?
Well, so there's one case that I do want to discuss. This is a case called U.S. v. Rahimi. The law here, which the Fifth Circuit struck down, is a law saying that if a court has determined, so if you have a restraining order against you, because a court has determined that you are a violent threat either to your romantic partner or to your romantic partner's child, then you may not own a gun. So, like, to be clear who we're talking about, there's been a court proceeding. The court has determined if this individual has a gun, they may use it to try to kill their wife, to kill their girlfriend, or to kill their girlfriend's child. This is the universe of people we're talking about here. The Fifth Circuit struck that law down. The Fifth Circuit said that wife beaters have a constitutional right to own a gun.
And this is because of the New York State case, right?
Yeah.
Where the Supreme Court said our gun laws have to look like they did in 1776.
Exactly. And like that brings me to the worst part of this Rahimi case. The worst part of the Fifth Circuit's decision in Rahimi is I think they got it right. I think that, like, if you accept that previous Supreme Court decision, Bruin, which said that you have to look at what the gun laws looked like at the founding to figure out which gun laws we can have now. Well, it was legal to beat your spouse in all 50 states until 1871. It wasn't until 1871 that the Alabama Supreme Court of all states ruled that it was you could indict someone for beating their spouse. So, and then there were 49 states where, it was still legal. So, if you accept what the Supreme Court said in Bruin, that we have to tie our gun laws to what the gun laws looked like in 1789, then I guess you have a constitutional right to own a gun, even if you are a violent threat to your own spouse.
And just to be clear, the law says that that there has to be a hearing to adjudicate this. So their law is not like making a sweeping assessment. It's saying that we're going to leave it up to the courts to be able to, like, look at this person and make this determination. So the long and short of it is that this case is going to force the Supreme Court to reevaluate what they did in Bruin, right? And it's got to be embarrassing for them.
I would hope so. Again, like, operating on the theory that Brett and Amy are not terrorists, like, I think any normal person hears this case, the holding of this case that I described, that people who a court has determined are a physical danger to their spouse, to the romantic partner, or to the romantic partner's child, has the right to own a gun. Any normal person hears this. No, that's wrong. That cannot possibly be correct. What I think is likely to happen is that Kavanaugh wrote a concurring opinion in Bruin where he said there are some categorical carve-outs to the Fifth Amendment, to the Second Amendment. So like you can't own dangerous and unusual weapons. You can't bring guns into sensitive places. I think the court will probably create a dangerous persons carve out or something like that. So if you've been determined to be a dangerous person by a court, then you can be disarmed. But again, like it's a pretty spooky case because like, you know, most of the time when I rag on the Fifth Circuit, it's because I think that they did something completely lawless. Here, I think they follow the law. The problem is that Gruen is insane.
Yeah, and I think it's going to make it really clear. I mean, the more carve-outs they have to this sort of like magical, we go back to what they were thinking in 1789, except for in these instances where we realize that's not workable, is just ridiculous.
Yeah.
Ian, I know you got to run. I hope we can do this again because as the cases are heard, it really appreciate your insight to these things. Thank you so much.
Thanks so much for having me, Sam.
Thanks, Ian.